I'm the chair of Holland and Hart's Health Law Group. Welcome to our next webinar in our series of compliance-related issues. Today, I'm going to be talking about the information blocking rule. A little bit of an overview. I'll cover kind of what the rule requires, the penalties for non-compliance, to whom it applies, what it prohibits, talk a little bit about some exceptions. There's actually a proposed rule out there that would change the information blocking rule. I will touch base on that and then finish up with a little bit of interaction about HIPAA, how this relates to HIPAA. This program is going to be recorded and it's available if you would like to listen to it in the future, if you haven't got anything better to do over the weekend or want to pass it along. Also, if you have questions, because we are recording it, we are not going to take questions during the program, but you may submit those questions to me using the chat feature, or you can email me here at the firm, and I will respond offline. In the materials, you should have received a copy of the PowerPoints along with links to some of the key documents. I want to point out those fact sheets from ONC. There's one on who the actors are as well as the exceptions. I think both of those are exceptionally good, and they can provide some good information to you as you work on implementing the information blocking rule. All right, with those preliminaries out of the way, let's talk about the information blocking rule. This is part of the 21st Century Cures Act. That Cures Act came out in 2016. It was designed to enable the exchange of electronic health information to facilitate better outcomes and to lower costs, and to also allow patients greater access to their health information. There were kind of two parts to that. The 21st Century Cures Act was huge, but the two parts that dealt with this electronic health information, there was one part that promotes interoperability of health information technology. You guys are probably familiar with that if you participated in meaningful use. This is part of it that requires you to incorporate those interoperability standards. If you are participating in that program, you have additional standards that you must comply with in addition to the information blocking rule, but I'm not going to cover those standards today. I'm just going to talk about the information blocking rule. That's the other part that from the 21st Century Cures Act, it prohibits information blocking. Specifically, in the statute that's cited up there, it states that for developers, networks, and exchanges of information technology, health information technology, any health IT developer, network, or exchange that the Inspector General, the Office of Inspector General, they're the policeman for this, determines to have committed information blocking shall be subject to a civil monetary penalty. When it comes to healthcare providers, the statute says that any healthcare provider determined by the Inspector General to have committed information blocking shall be referred to the appropriate agency to be subject to appropriate disincentives. We'll talk more about that in just a minute. So that came out in about 2016. In 2020, the Office for the ONC issued their information blocking rules. The information blocking rules implement the Cures Act, and it prohibits actors from engaging in any practice that is likely to interfere with, prevent, or materially discourage access or otherwise inhibit the access, exchange, or use of electronic health information, unless the action is required by applicable law or you fit within a regulatory exception. So this is the guts of the information blocking rule. A couple of points here. It only applies to actors. We'll talk about that in just a minute, who those are. What is the standard for information blocking? Well, it's engaging in any practice that, again, is likely to interfere with, prevent, or material discourage access or otherwise inhibit the access, exchange, or use of electronic health information. The information blocking rule only applies to electronic health information, not all information, just electronic health information. But there are two big exceptions. The information blocking rule does not apply, or you're not deemed to be engaging in information blocking, if whatever you're doing is required by applicable law, or if you fit within one of the 8 regulatory exceptions that are included in the information blocking rule. Okay, that's pretty much summarizes the rule. So let's talk about who it applies to. The information blocking rule applies to 3 entities. These are referred to as actors. There are healthcare providers, developers of certified health IT, and health information network or exchanges. Most of my clients are healthcare providers. Who are healthcare providers for purposes of the information blocking rule, basically anybody. It's a long list. It's physicians, practitioners or therapists, a hospital, nursing facility, group practice, clinic, ASC, FQHCs, RHCs, laboratories. Pretty much if you are a healthcare entity and you're engaged in, you have electronic health information, then you need to be concerned about the information blocking rule. It also applies to developers of certified health IT. Not all health IT, just if you're a developer of certified health IT. A developer of certified health IT is an individual or entity, should be an individual or entity, that develops or offers certified health IT other than a healthcare provider that self-develops health IT for its own use. Important point here, you can be in more than one type of actor. So for example, you may be a hospital that has developed your own health IT program. If that's the case, then you may be covered by the health information or the information blocking rule, both in your capacity as a healthcare provider and in your capacity as a developer of certified health IT, if you're making that available to others outside your organization. The standards that apply to those different entities differ. So just make sure that if you're, for example, a hospital, that you're not, you just don't apply those standards. If you have also developed certified health IT and are making those available to others. Note that a developer of certified health IT does not apply to a healthcare provider that develop its own health IT. So if you come up with your own program for only your internal use, that, at least under the current law, does not make you a developer of certified health IT. But once you make that available to others, so again, maybe you're a health system, if you decide to come up with a program and you make that available to your medical staff members who are outside your particular organization, then that could turn you into a developer of certified health IT. It also applies to health information networks or exchanges. So if you are a health information network exchange, make sure you look at the regulation to confirm whether you fit within that definition that triggers your obligations. Now, as I mentioned, the information blocking rule only applies to electronic health information, or EHI. Electronic health information, they basically borrow the definition for electronic health information under HIPAA. So electronic protected health information, electronic health information of the information blocking rule is any EPHI under HIPAA that would be included in a designated record set. So it only applies to that EHI that's in a designated record set as defined by HIPAA, regardless of whether the electronic health information is used or maintained by or for a covered entity as defined in 45 CFR 160.103 or HIPAA. So unpacking that a little bit, let's talk a little bit about that. EHI applies even if you're not a covered entity under HIPAA, but you have EHI, then the information blocking rule still applies to you if you're an actor. So developer of certified health IT, they're not a covered entity under HIPAA, but they still are going to be subject to the information blocking rule if they've got EHI. It only applies, somewhat like HIPAA, it only applies to electronic health information that would be maintained in a designated record set under HIPAA. So it's not all information you may have relevant to a particular patient, but it's only the information that would be in a designated health record set under HIPAA. The information in a designated record set under HIPAA is generally the information that's used to make decisions about a patient's health, healthcare, or payment for their healthcare. So if the information you've got is used to make decisions about the patient's health or healthcare or payment for the patient, then it's probably going to be part of the designated record set, and it would be considered electronic health information and subject to the information blocking rule. Now, there's a couple of exceptions. The EHI, electronic health information, for purposes of the information blocking rule, does not include psychotherapy notes as defined under HIPAA. Just a note here, psychotherapy notes as defined under HIPAA, it's not mental health records. Psychotherapy notes is a very, very limited set of information. It's basically just the notes that a psychotherapist or a therapist, a mental health care provider would prepare, kind of like their handwritten notes or their notes that they would use to then create the regular record, right? It's that internal stuff that they're supposed to use for their own use to maintain, to create other health records. It's those notes would be separate from anything that goes into the health record. So once it goes into the health record, it's not psychotherapy notes. So just don't get confused and assume that all mental health records are psychotherapy notes, because that is clearly not the case. Psychotherapy notes is very, very limited. So as a general rule, then the information blocking rule is still going to apply to your mental health records. It also excludes information that's compiled in reasonable anticipation of or for use in a civil, criminal, or administrative action or proceeding. But those are pretty limited exceptions. The general rule is, hey, if this is electronic protected health information that's maintained in a designated record set, then it is EHI for purpose of the information blocking rule, and you generally have an obligation to not unreasonably interfere with another entity's access or providing that information to another entity. What are the penalties if you violate this? Well, if you are a health IT developer, a health information network, or a health information exchange, there's a process that's in place. Complaints are made to the Office of National Coordinator for the Healthcare IT. The ONC then does its investigations. Under a proposed rule that they have issued, it would allow them, consistent with the statute, to impose civil monetary penalties of up to $1 million per violation. That is a huge risk for health IT developers, HINs, and HIEs. Okay. On the other hand, if you're a healthcare provider, consistent with the statute, the regulation just says that you can be subject to appropriate disincentives to be established by HHS. We do not have the rules yet for healthcare providers. We do have at least the proposed rules for health IT developers, so health IT developers are at risk, but healthcare providers, right now we don't have the rule. So that's probably why you who are healthcare providers haven't worried too much about the information blocking rule, as there are no penalties yet, at least nothing that can be imposed per the regulations. So, but you know, watch, I mean, that's going to be coming down the pipe. So don't just ignore this stuff. As I mentioned, under the current rule that if there is a complaint, somebody who has a complaint, they can hop on the ONC's website, they submit the claim electronically to the ONC, then the ONC does its investigation. So far, there have been a total of 764 complaints. This just breaks out who's making the complaints. I thought it's interesting that most of the complaints that have been made have been coming through by patients. I'm somewhat surprised that they're asserting those complaints through the information blocking rule rather than just through HIPAA, because the patients would generally have a right to access their information under HIPAA. And there is a penalty structure under HIPAA. We don't have a penalty structure yet for healthcare, at least for healthcare providers, under the information blocking rule. But be that as it may, that's where we are as of May 2023. Now, an important point. To violate the information blocking rule, you must act with the relevant degree of knowledge, or mens rea. And that knowledge standard differs depending on whether you are a health IT developer, HIE or HIN, or whether you're a healthcare provider. If you are a health IT developer, HIE or HIN, then the standard is whether you knew or should know that the practice that you're engaging in was likely to interfere with, prevent, or materially discourage access, exchange, or use of EHI. So it's a know or should have known standard, okay? It doesn't matter if you didn't think that it did. If you should have known that it violated or was likely to interfere, then it's a violation of the information blocking rule. On the other hand, if you're a healthcare provider, the government's a lot more generous to you. For healthcare providers, you can only be liable for a violation of the information blocking rule if you know that such practice is unreasonable and is likely to interfere with, prevent, or materially discourage access. So it's not know or should have known, it's whether or not you apparently had a subjective knowledge that the practice you're engaging in was unreasonable and is likely to interfere with, prevent, or materially discourage access, exchange, or use of EHI. So it's probably going to be a lot harder for the OIG to impose penalties against healthcare providers than they would against the health IT developers, HIEs or HINs. But, be careful, healthcare providers. This gives you quite a bit of protection, but you can't just necessarily stick your head in the sand there, because if you know that it's unreasonable, then you could still be subject for penalties if and when those penalties come out. So what are some examples of information blocking? Well, it could be refusing to timely respond to requests for EHI from patients or others. Could be requiring a patient's written consent for EHI when it's not required by HIPAA. So for example, under HIPAA, there's certain times you need the patient's written authorization. There's other times that you don't. Generally, you're not required to get the patient's authorization to make disclosures for treatment, payment, or healthcare operations. For example, treatment or payment purposes for another healthcare provider. So if you refuse to provide that simply because it's your practice not to provide that information to another healthcare provider, you refuse to provide that EHI, well, then that may be a violation of the information blocking rule, even though it's not a violation of HIPAA. So if you require the patient's written consent when it's not required by other applicable law, then that could be an interference. Charging excessive fees to obtain the EHI, imposing unreasonable administrative hurdles before sharing EHI, imposing unreasonable contract terms that prohibit sharing EHI. So for maybe your EHR agreement or your BIAs, it prohibits you from sharing or because of maybe licensing issues or things like that, that it prohibits you from sharing that protected health information, that EHI, with others. Well, that could violate the information blocking rule if those contract terms are unreasonable and unless they fit within one of the exceptions. It could be implementing health IT in non-standard ways so that it increases the burden. You have a program, but you intentionally implement it in a way so that it's not interoperable and it makes it more difficult to share the information. That could constitute information blocking. Well, what is not information blocking? And by the way, those aren't the only ways you can engage in it. Any action that, if you're a healthcare provider, unreasonably interferes with sharing this electronic health information with others who can get it, then can lawfully request it and can lawfully get it, then that is potentially information blocking. Well, what is not information blocking? Well, if the action does not interfere with the access, or if you're a healthcare provider, does not unreasonably interfere with access, then that's not information blocking. It only applies to, at least for providers, actions that unreasonably interfere with the access. If the action is required by law, so if you refuse to produce the information because there is no HIPAA exception, and HIPAA generally requires the patient's authorization, you don't have the patient's authorization, then that's not information blocking because another law requires you not to provide that information. So it could be HIPAA, 42 CFR Part 2, if there's state privacy laws that prohibit you from making those disclosures, then that's not a violation for under the information blocking rule if you comply with those other laws. Similarly, if another law requires that you satisfy certain conditions before you can make that disclosures, and if those conditions have not been satisfied, then you're not required to provide it. So for example, under HIPAA would allow you to make the disclosure, but only if you have the patient's authorization. If you don't have the patient's authorization, then the condition has not been satisfied, so you can't provide the information. It's not information blocking because you are complying with this other law. It's not information blocking, at least for healthcare providers, if the action is reasonable under the circumstances or you fit within one of the regulatory exceptions. There are 8 different regulatory exceptions in the information blocking rule. It's not absolutely essential that you fit within these exceptions, but if you don't fit within the exceptions, then you go back to the general parameter, was it likely to interfere? That would be the standard. So let's talk briefly about these exceptions. They can be broadly categorized in 2 different groups. There are 3 exceptions that apply to the manner in which you actually fulfill the request. And then there are 5 exceptions that apply when you're not going to fill the request. You're simply not going to give the information. Then you want to make sure that you fit within or try to fit within one of those exceptions. Let's talk about each one of those. First, the exceptions that apply if you're simply not going to comply with the request. The first one is the preventing harm exception. That allows an actor to block EHI if it has a reasonable belief that the practice will substantially reduce a risk of harm to the patient or other person. For example, to avoid the risk that the corrupt or inaccurate data will be incorporated into the patient's electronic health record, or upon a determination by a licensed healthcare professional that the disclosure is likely to endanger the life or physical safety of the patient or others. There are a bunch of additional criteria that have to be satisfied for this exception, but this is kind of just an overview. This really goes for all of these exceptions. I'm just going to give you kind of an overview of what the requirements are, but in all of them, there are very specific requirements that have to be satisfied. So before relying on that exception, you'll want to look at the actual regulations or look at the ONC guidance to make sure that you can actually fit within that exception. So the first one is you're going to not provide it because you can't provide it if you want to prevent harm, but you would want to make sure you fit within the specific requirements for that. The next one, if you want to protect the patient's privacy. This exception allows an actor to block the EHI if state or federal privacy laws impose preconditions to access that have not been satisfied. So for example, under HIPAA, you don't fit within any of the exceptions and you don't otherwise have the patient's authorization. If HIPAA allows the actor to deny access to the individual, or the patient has requested that her or his information not be shared. That's a separate sub-exception to that. Again, in each of these situations, the actor must satisfy additional regulatory conditions associated with those, but those are the general situations to which that exception applies. Next exception, if you're going to deny access or deny sharing in order to protect the security of your system. This exception allows you to block the EHI if necessary to safeguard the confidentiality, integrity, and availability of the EHI consistent with your own organizational security policies, or a specific determination that you don't have a specific security policy, but you make a specific determination that there are no reasonable, less obtrusive alternatives to secure the EHI. So you need to secure the EHI by not granting access. But again, you want to look at the regulations and make sure you can comply with the additional specific criteria that are established. Next exception, if access is simply infeasible under the circumstances. So under this exception, an actor may block access to the EHI if there are extraordinary circumstances beyond your control that prevent you from fulfilling the request, and you cannot segregate the requested information from other information that's not subject to access, or the actor demonstrates or you demonstrate that responding to the request is not feasible due, for example, the type of information that it is, the cost, your available resources, the control of the relevant platform, etc. It's simply beyond your control, right? Then you may be able to fit within this exception. If you are going to deny access based on this infeasibility exception, within 10 days of the request, you've got to notify the requester in writing of the reason for your failing to provide the requested access to see whether they can come up with some solution. Again, check the specific regulations to make sure that that applies. Finally, there's an exception that allows you to deny or delay access to that if you need to, perform your maintenance or secure your information, kind of on a routine maintenance process. So let's talk about situations now where you are willing to go ahead and provide it, but you're going to change the manner or put conditions on the manner in which you are going to provide it. In this one, the first exception is the content and manner exception. This allows an actor to, it basically states that an actor must generally provide the access to the EHI in content in the manner that the requester requested it, unless you're technically unable to fulfill the request or cannot reach agreeable terms with the requester to fulfill the terms. If the actor cannot grant access as requested or agreed, the actor must take reasonable steps to fulfill the request in an alternative manner consistent with specified technical standards. So it doesn't necessarily say, well, it's too difficult for us, or I can't provide it in the content or manner. You've got to take reasonable steps to see if there's a way that you can provide it. But if you cannot, under the particular circumstances, then you may rely on this content and manner to provide alternative, the information in an alternative manner. The next exception is fees. Under the information blocking rule, an actor may charge a reasonable fee for access in exchange or using the EHI so long as those expenses are based on the provider's costs and are applied in a non-discriminatory manner as more fully described in the regulations. A word about this. So I'm going to talk about some FAQs in a minute. The FAQs basically say, hey, anytime you impose fees to access the information, that's presumptively violation of the information blocking rule unless you can fit within the exception that allows you to impose fees. So before you're going to charge fees, you're going to want to crack open the regulations, take a look at this particular exception, make sure that the amount of fees that you are charging satisfies this particular exception. Finally, there's an exception for licensing. You are going to go ahead and provide the information, but in order to do that, you're going to require the person to acquire a license in order to get that information. Under this exception, the actor may license interoperability elements so long as the actor begins licensing negotiations within 10 days from the request to access the information and the license satisfies specified regulatory standards. Among other things, any royalty that you're going to charge must be reasonable and the license terms must be applied in a non-discriminatory manner. So it's not like you're just keeping this out of the hands of a competitor or something like that. All right, that's a very brief overview, just to kind of give you an idea of what the exceptions are out there. When it comes time to applying those exceptions, you're going to want to, again, look at the regulations or go to the ONC's, the Office for the National Coordinator of Health Information Technology, go to their website or go to this PDF, and it talks about what are the requirements for each one of those exceptions. All right, so let's step back now. Here's the general analysis to determine whether or not what you're doing is information blocking or not. Whether it's information blocking, it really depends upon the facts of any particular circumstance. And within that circumstance, it depends on the following factors. Is the individual or entity engaging in the practice an actor? If you're not an actor within the meaning of the information blocking rule, then the information blocking rule doesn't apply to you. Next, does the claim involve EHI? If it's not EHI, if it's just purely in paper form, or if it's psychotherapy notes, even though that would almost never occur. If it's not EHI, then the information blocking rule doesn't apply. Was the practice, is your refusal to provide the information, you're refusing because the law prohibits you from providing that information? If so, then it's not information blocking. Does your action, your blocking action, doesn't meet one of the conditions for an exception under the information blocking rule, one of those 8 exceptions we talked about? If it does, then it's not considered information blocking. Did the practice rise to the level of an interference? So remember, you may engage in certain stuff, but if it's not interfering, not truly interfering, then it's not information blocking. And information blocking is only those actions which are likely to interfere with the access. And finally, did the actor meet the requisite knowledge standard? Remember, that's a different standard. For providers, the test is whether or not you knew that such practice is unreasonable and is likely to interfere with access, exchange, or use of electronic health information. For health IT developers, HINs and HIEs, the standard's a little bit looser. If you're one of those entities, the test is, did you know or should you have known that the practice is likely to interfere with the access, exchange, or use of the EHI? Okay, so those are the questions that you would ask. That would be the analysis that you would go through to determine whether or not your particular denial of access constitutes information blocking or not. All right, so that's the general overview. Let's talk about some of the refinements, particularly some of the guidance we've gotten from the ONC in their published FAQs. You can access those FAQs at this particular website. First, can prior agreements, arrangements, or contracts still in effect implicate the information blocking definition? So you had an agreement in place before the information blocking rule. Can you still comply with that contract if it prohibits you from disclosing the information? No. Once the information blocking rule comes into effect, then generally it preempts contrary contract terms. So you got to comply with the information blocking rule unless you can fit within one of those exceptions. What about paper records? Remember, the information blocking rule only applies to EHI. What about if a patient comes in there and says, hey, I want you to take my EHI and give me a PDF or give me a paper copy of that? Is the electronic information rule, the information blocking rule, implicated? Yeah, It is, because you're still accessing the electronic information. It's just you're going to produce it in a paper form, so it would still be implicated in that situation. What about draft notes? This is one of them that's the most controversial, because you normally don't think about your draft notes as being accessible. I mean, that's until they're finalized, you think no one else ought to get them. So this particular FAQ said is non-final clinical information, such as draft clinical notes or incomplete test results that are pending confirmation, included in the definition of EHI for purposes of the information blocking rule, such that you would have to provide access to that, even though they haven't been finalized or the test hasn't been confirmed? The answer to that, well, it depends. If that information is in a designated record set, so it would be used to make decisions about the patient's health care or payment for their health care, then it would be subject to the information blocking rule. Even if it hasn't been finalized, you would still have to provide access to that information. So the answer says if such data are used to make healthcare decisions about an individual, then that data would fall within the definition of designated record set and therefore within the definition of VHI. To the extent that the data points fall within the definition of EHI, practices likely to interfere with legally permissible access, exchange, or use that EHI could implicate the information blocking definition, including unreasonable delays in providing that information. We'll talk more about that in just a minute. Well, does the information blocking rule require you to go in and affirmatively upgrade your equipment in order to allow access more easily? The general rule is no. The info blocking rules do not require you to use Health IT certified under the ONC, interoperability standards. You're not required to upgrade to that. But if you are otherwise participating in meaningful use or are otherwise required to have those interoperability standards, then you're certainly required to comply with those requirements under that different program, not necessarily under the Health IT program or the information blocking rules. Well, what about, does the information blocking rule require you to affirmatively send out your electronic health information, to proactively provide it? Specifically, this question says, do the information blocking regulations require actors to proactively make EHI available through patient portals, application programming interfaces, or other health information technology? So does the rule require you to put in place patient portals? The answer there is probably no. That's what they originally said, but then they came back with some mealy-mouthed alternative answers to this FAQ, which basically said that proactively or proactive is not a regulatory concept, including within the information blocking regulations, that we simply don't address that under the information blocking regulations. However, under a different FAQ, they did reaffirm that while the information blocking regulations do not require actors to proactively make EHI available, once a request to access, exchange, or use EHI is made, then you've got to timely respond to the request. So the net result is that no, the information blocking rule does not affirmatively require you to go out and implement patient portals or send out stuff through patient portals. But once a request is made, you've got to respond to that request. So it doesn't affirmatively require you to push it out, but once you have that request for it, you've got to make it available. You can't block the access. Well, then does that mean that always determines your compliance always depends on a request? Well, you would think so, and I think that's probably the way it works in most cases. It only is triggered if you get a request. However, there is a specific FAQ, and in this FAQ they say, is a claim of information blocking predicated on a request for access? In other words, does someone always have to ask an actor for EHI before the actor's practice could violate the information blocking definition? The answer there, according to the ONC, was no. That the facts and circumstances will determine whether the information blocking regulations are implicated. They go on to state that any act or omission, whether or not in response to requests for access, could implicate the information blocking regulation if the act or omission interferes with, prevents, or materially discourages the access, exchange, or use of EHI. For example, the practice of implementing health IT in ways that are likely to restrict access, exchange, or use could violate it, or the practice of including a contract provision that restricts access, exchange, or use could, under certain circumstances, implicate the information blocking regs, or omissions could similarly implicate the information blocking regs. For example, if you fail to exchange EHI the failure to make EHI available for use, or not complying with another law that requires the access, exchange, or use of EHI. All of those are situations that the information blocking rule could be violated. All right, let's talk about fulfilling the requests. This FAQ says, is an actor required to fulfill a request with all the EHI they have for the patient, or should the amount of EHI be based on the details of the request? So are you only required to produce the information in response to the request, or must you, if you get a request, produce everything? The answer there is no, you only have to comply with the request. Okay, but just be careful there. In particular, if that information is within your designated record set, even if you got it from another healthcare provider, you still have to produce it under HIPAA, but also under the health information blocking rule. So just because it's provided or was created by another healthcare provider doesn't mean that you can block access. There's no exception for that under the information blocking rule or under HIPAA. If it's in a designated record set, then it's subject to that disclosure. What if an actor only maintains some of the requested information electronically? Well, then you only have to produce the information that's maintained electronically. Or if the applicable law only requires you to, or allows you to produce certain information, you can only produce the information that's allowed by that certain law. Well, what about delays? Is it information blocking if you delay producing the information, particularly in the context of lab tests? If you've got a policy that says, we're not going to provide access to the patient until after the physician has taken a look at that. Well, here's what the FAQ says. Are actors, for example, healthcare providers, expected to release test results to patients through a patient portal or application programming interface as soon as the results are available to the ordering clinician? The answer, once a request to access, exchange, or use EHI is made, the actors must timely respond to the request. Delays or other unnecessary impediments could implicate the information blocking rule, including requests for test results. So it doesn't affirmatively require you to send out that test result to the patient, but if the patient comes in there and says, hey, I want my test results, you cannot delay and refuse to provide that just because the physician has not taken a look at it yet, unless you can fit within one of the exceptions. So back to the FAQ, it says, in practice, this could mean a patient would be able to access EHI such as a test results in parallel or at the same time that that test result is available to the ordering clinician. You can't just have a general policy that you're not going to provide that information until after the physician looks at it. They give you a couple of examples of the types of things that are likely to be interference and those that are not likely to be interference. Likely to be interference, according to the FAQ, would likely be an interference if a healthcare provider established an organizational policy that, for example, imposed delays on the release of lab results for any period of time in order to allow an ordering clinician to review the results, or in order to personally inform the patient of the results before a patient can electronically access such results. So again, this does not affirmatively require you to push out those electronic test results, but if you have those electronic test results available, then you've got to make those available to the patient if requested. Where a delay in providing access, exchange, or use occurs after a patient logs into a patient portal to access EHI that a patient healthcare provider has, including, for example, lab results, and such EHI is not available for any period of time through the portal, then that could be an interference. So again, it doesn't affirmatively require you to put this stuff on the portal, but if it is in there on the portal, then the patient should be able to access it immediately. Where a delay occurs in providing a patient's EHI via an API to an app that the patient has authorized to receive the EHI, if you have some kind of policy against delaying or to delay that, then that could be interference. Well, what about unlikely to be an interference? Well, if the delay is necessary to enable the access, exchange, or use of the EHI, it is unlikely to be considered an interference under the definition. If the release of EHI is delayed in order to ensure that the release complies with state law, that's probably not an interference. Or in scenarios where the EHI must be manually retrieved and moved from one system to another system, that's not an interference. In those situations, you're not unreasonably delaying the disclosure or access to that information. Well, what if the delay is required by other laws? Well, again, under the information blocking rule definition, it's not interference. It's not a violation of the rule if what you're doing because another law requires it. So if another law requires and says you cannot produce this information for 5 days or so, then compliance with that other law does not violate the information blocking rule. On the other hand, if another law simply permits you to delay the disclosure, then that does not get you out of the information blocking rule. So for example, under HIPAA, HIPAA says you don't need to produce records in response to a request from the patient for 30 days. Well, under the information blocking rule, that 30-day deadline may be unreasonable. If you can produce it before then and you intentionally delay the 30 days just to comply with HIPAA or because HIPAA allows it, well, that could still be information blocking because you've unreasonably delayed the production of that. What about charging fees? Well, as I mentioned earlier, yeah, charging fees is presumptively a violation unless you can fit within the fee exception. So you'd want to look at that. They've stated in the answer to this FAQ, we have consistently interpreted the broad definition of information blocking to encompass potentially any fee that is likely to interfere with, prevent, or materially discourage the access, exchange, or use of EHI. This would include any fees charged to individuals for copies of their EHI furnished on paper or electronic media. But what if the patient requests that you not disclose it? Well, under the patient privacy exception, there's a sub-exception that basically says, hey, if the patient tells you not to do it, then you don't have to make that available. That's protecting the patient privacy. Unless, of course, another law requires you to make that disclosure, then you would be required to do it. Again, if the law prohibits access or disclosure, then it's not information blocking if you comply with that law. That brings us to HIPAA, which is the big law out there that normally overlaps. Just think of it this way. When it comes to HIPAA and the information blocking rule, if HIPAA allows but doesn't require you to do something, but the information blocking rule does require you to do it, then you go with that. If HIPAA, on the other hand, prohibits you from making the disclosure, then that's not a violation of the information blocking rule. You comply with the most restrictive of the two. So to briefly summarize the interaction with HIPAA, if HIPAA allows access or disclosure, then the IBR generally in that situation prohibits information blocking. So HIPAA would allow it, but the IBR says you cannot block the access. So you would generally be required under the IBR to provide that access, so long as HIPAA does not prohibit you from doing so. So specifically in the situations where HIPAA would allow you to make disclosures for treatment payment and some healthcare purposes to another healthcare provider, then even though HIPAA says you may make that disclosure, the IBR says you must make that disclosure. If you fail to make that disclosure, that could constitute improper interference. We already talked about the delay period, the time for producing it. Even though HIPAA says you may have 30 to 60 days to respond to a patient request, the IBR says, no, you got to respond to it earlier than that. It could be, an unreasonable delay could violate the IBR. On the other hand, if HIPAA or another law prohibits the disclosure, it's not information blocking if you comply with that law. So if HIPAA says you can't make this disclosure unless you have the patient's consent, or you have the patient's authorization, or certain conditions under HIPAA have been satisfied, then it's not information blocking if you require compliance with that before you produce the records. As I mentioned, there are proposed changes to the information blocking rule. A proposed rule was issued in April of 2023. It would narrow what it means to offer health IT developers. Remember, an actor is a health IT developer. It does not include healthcare providers who develop their own IT unless they offer it outside to others. So they narrowed what it means to offer under this particular proposed regulation. The proposed rule would confirm that healthcare providers who self-develop certified health IT are not developers if they're outside that definition of offering the health IT. It confirms that the information blocking rule applies to all electronic health information, not just those data elements that were in the USCDI. When the information blocking rule first came out, it only applied to the data elements that were in the USCDI, but in October that was changed so that it now applies to all data elements, all electronic health information. And the proposed rule would modify certain exceptions, including the infeasibility exception and that content and manner exception. So watch for those changes, not huge, but they could be relevant. So watch for the proposed rule to see whether it's finalized. Just so you know, there also are pending changes to HIPAA out there. The proposed rule was issued, I think it was all the way back in 2021. We do not have the final rule yet. Among other things, that rule would make certain changes to coordinate with the information blocking rule. All right, so those are the rules. What do you need to do? Well, if you are a developer of certified health IT or HIE or HIN, you'd better be complying with the rule now because you could get help with those penalties. If you're a healthcare provider, you probably shouldn't stay awake too late right now because there are no penalties out there against you, at least now. But those rules will be coming down the pipe, so don't think you're going to be able to avoid it altogether. So you may want to consider the following. First of all, take advantage of the new rule. To the extent that you want to get information from another healthcare provider or another entity, and that other entity prohibits you from getting it or refuses to provide it and doesn't have a good basis, then you can cite the information blocking rule and say, hey, you've got to give me that information. You're required to give me the information. So you may use it to your advantage. You should confirm your status as an actor. Are you a healthcare provider? But if you are you also a health IT developer? Make sure that you understand the rules that apply to each, and don't just assume that just because you're a healthcare provider, you're not also a health IT developer if you have developed your own certified health IT. Identify and educate relevant stakeholders, the persons in your organization, so they understand the requirements of the information blocking rule, including those who, in information systems or the like, who are responding to requests for information. Your technology people, so that they understand the parameters and the requirements, including requirements that may be violative that appear in contracts, or when you're implementing your health IT, make sure that you're not putting in processes that unreasonably interfere with your ability to exchange information. Review your EHR functionality to make sure it's not overly put in place in a non-standard way such that it's, you're doing it in order to avoid having to share information. Review your relevant contracts to make sure that they haven't got terms in there that are antithetical to the information blocking rule. Review and modify your electronic health information practices, like things like, do you have a policy that prohibits making test results available to a patient immediately? Do you have a policy that prohibits providing information over to other healthcare providers without a written authorization from the patient? Look at those policies because, evaluate whether those are potential violations of the information blocking rule and revise those as appropriately. Make sure that you respond appropriately to requests for access or sharing. Don't just ignore them. Don't just say, we're not going to do that. We're not required by HIPAA, so we're not going to do it, because the information blocking rule may require you to do that. And of course, watch for further developments and guidance, including those enforcement rules when they come down, further guidance from the Office for the National Coordinator, and the proposed HIPAA modifications and the proposed IBR rule when they come out, to see how they're going to apply. All right. For more information about the information blocking rule, the ONC has an extremely helpful website that has summarizes the IBR requirements. It contains fact sheets for actors. What is EHI? What are the exceptions? When do they apply? It has those FAQs, some of the more relevant ones we talked about today. It's got blogs for education. It's got webinars that help train you concerning the information blocking rule requirements. We've also got information on our website that is free, including my article that I provided to you that summarizes these rules. And that is it. That is a very brief overview of the information blocking rule. If you have any questions, feel free to submit those using the chat feature, or just shoot me an email and I'll try to respond to those offline. Otherwise, there it is. Go forth and share your information to the extent required by the information blocking rule. Thanks, and have a good day.